Welcome back to our channel. Today we're going to focus on the topic of contracts, which produces the most questions on the National Real Estate Exam. Whether you're exposed to PSI or you're exposed to Pearson VUE and you're looking at the bulletin, you will see most questions are on the topic of contracts. The focus is on termination. If you haven't subscribed, go ahead and do so. Like, comment, and we shall see you next time. Welcome to a conversation on termination of contracts. What we're going to start off with is a review of what is it that is required to be in a contract. There's a video that we have that is linked to the description that you're able to go deeper on the topic of contracts. Let's start off with, what does every contract need to have? Since real estate is driven by contracts, we need to go back to contract law, whether you're doing something in real estate or you're doing something with an attorney, your accountant, your social media expert, your branding expert, your staging person, your photographer, your landlord. Notice all of these are different types of contracts. We do need to review that it needs 5 elements of a contract. In order for us to say we have a contract, we need to have the 5 things. Offer and acceptance. Somebody made an offer, somebody said yes, and both sides now know where we are, and that is delivery. Consideration would be anything of value that you are proposing and accepting as a result of this agreement. Some of us might simplify that as money. However, it is anything of value and accepted by both parties to this contract. We need consent, sound mind. People need to have an idea as to what they're getting themselves into in this particular arrangement of a contract. It needs to be legal. And the last one is competency, where we need the individual to be of legal age. And in most states, that is going to be the age of 18. So there are different types of contracts. In review, in real estate, we have the agreement between the broker and the seller when we're listing a property for sale. So that's the listing agreement. We then have the buyer representation agreements between the buyers and the brokers. Property management, when you've been hired to manage the property between you and the owner of the property. The other types of agreements that we might be exposed to in real estate is owner financing or installment contract or land contract, where the owner is acting as the bank. We have the vendor is the owner, giving access to the property to the vendee, and there's installments, and the vendee doesn't get ownership until the final payment. Sales agreements, some of you label that also as purchase agreements between the buyers and the sellers. And the other type that you might be exposed to is a lease. With all this type of real estate contracts, they do get to a point where they're going to terminate, where we're going to end that particular contract. So what are the ways we are able to terminate a contract? We're going to go through the conversation of terminating the contract, the definition of rescission, and then what else would make it possible for us to cancel the contract. If we start with the first one, rescission. This is where we're circling back. We're circling back from where we are, and we're going back to their original point. Original point means we're starting all over. Everything is now canceled. If there was any money exchanged, money has been returned. Usually, rescission is provided in some of our contracts through operation of law. Let me give you a good example. In Maryland, we have some properties that have condo rules and then some that have under the guidance of a homeowners association. The individual who's selling the property is to provide the rules and the conditions to the buyer who's interested to purchase that particular type of a property that comes along with some restrictions or guidance or practice. Once the individual receives those documents, operation of law in terms of rescission allows this particular buyer to go ahead and say, you know what, these rules don't work for me. And once that is presented, then through rescission, the contract is canceled. And because the laws do provide that, as long as it's within a window, in my case, in Maryland, 7 days from receiving those documents, then the buyer has the opportunity to walk away. And then we tackle any money that has been exchanged by addenda. So that's an example of operation of law. And then sometimes the contract terms are going to provide a window for someone to rescind. If, for example, you added an addendum that addresses financing and somebody's not able to get the financing, then as a result of that particular addendum, that allows us to go back to the original point and money is tackled separately or based on what is in the contract terms. The other way that a contract would be terminated is through a breach. Break. This is where somebody is breaking the promises. Somebody is failing to meet what we agreed upon. Whether it's on purpose or by accident, somebody isn't doing what we promised to do in the agreement. So what would happen? The person who did not break the promise, the non-defaulting party, then has options. If, for example, we had an honest money deposit that was put down, the non-defaulting party could have the opportunity to keep that because they're not the ones who broke the agreement. And then sometimes maybe it's on the other side. In terms of seeking monetary damage, let's flip it to the side of it is the buyer who is the non-defaulting party. So the seller is the one who breached. Then the buyer might seek monetary damages to where they want to be compensated for the cost they might have already incurred so far, whether examples of home inspection, appraisal, etc. So this is labeled simply as liquidated damages. The other option, when somebody has breached the contract, is a suit of specific performance. This is where you're taking each other to court and you are enforcing the defaulting party, the person who breached, to go ahead and still continue with completing the contract. The examples you might have heard on this one is where the buyer decides that they're not going to show up at settlement for whatever reason outside of the terms already provided in the contract. So this is if financing was an addendum addressed and they have their financing, but now they're walking away just because they don't like the area anymore, for example. Then the seller can file a suit to specific performance and request the judge to kind of make the buyer still compensate and purchase the property. Suit to specific performance. You're taking each other to court on performing something specific in the contract that was not addressed. Hopefully that made sense. The other way a contract is when we're talking about suing each other is statutes of limitation. So statutes of limitation as a definition addressing the suit for specific performance or suing each other because somebody didn't do what they promised to do is there's a time frame or a window that we have in order to take each other to court to enforce the promises made. Each state will have their own time frame. So for example, Maryland, that is 3 years, statutes of limitation. Other ways the contract is going to be terminated, and we're going to review some of them again that I might have already gone through, is I did what I was hired to do. You hired me to help you find the house, we did that. You hired me to help you sell the house, we did that. We found the house that you wanted. The other example would be the sales contract between the buyer and the seller. We've gotten to settlement, then we are done. Expiration. So again, not every contract will have an actual expiration date, but the agreements between the brokers and the clients maybe would. So expiration is the example where it is a listing agreement with the seller or the landlord, and then you have an agreement between the buyer and the broker. Those might have an expiration date. Once the expiration date is upon us, that agreement has been terminated unless what? There's an extension to sign on for more time. We covered breach. And then the other way that a contract could be terminated is mutual agreement. Either party sends a notice or tells the other side, you know what, it's not working out, or I've decided to do something different, or I've decided to go with someone else. So that's mutual agreement on terminating the contract. When you are going to review this particular topic of contracts, it's very helpful for you to have the exam bulletin. If you don't have access to that, it's going to be provided in the description. This is where it's going to be your guide, your table of contents that breaks it down for you. What is it you can expect on that particular exam? So when we're looking at the contract topic, you're seeing what are the things that you need to pay attention to. Some of these we have videos that we're going to link to on the description, or you can find them on our channel, and we have a playlist on the topic of national. And then for my friends in Maryland, we have a playlist on Maryland content. So I need to know about executory versus executed contract. I need to know about breach, which is what I covered in this particular session. We need to go through bilateral or unilateral contract. What's the difference? And then clauses, amendments, or addenda. When we're talking about a purchase agreement or a sales agreement, what are some of the stuff we need to be aware of, including contingencies and time is of the essence? How do counter offers work? And then on the other side, for the individuals who are exposed to Pearson VUE, the topic of contracts is under real estate contracts and agency, where you will see, similar to PSI, what's the difference between express and implied? What are the elements of a valid contract? Hint, you can go back to the beginning of this video and review that. We get into contract performance, valid versus void, unenforceable, statutes of frauds, and as you can see, number 4, for those of you under Pearson VUE, for those states that have that as your testing facility, that's what I just covered. Sales contract or purchase agreement, what do we need to be aware of? And then types of agency, because it's all lumped up into one topic. So this is where we're just reviewing the topic of contracts and what you would find. Continue this conversation by checking out other videos that are available on our channel. And if you haven't subscribed, go ahead and do so. We shall definitely continue building this channel. I will see you next time. That was awesome, right? You like our style? I look forward to helping you reach your goal of passing the real estate exam. We offer group coaching sessions on a monthly basis, and we also have tutor sessions that would match your availability. Show the love. Go ahead and subscribe. Put your comments in the video here, and we shall respond. Go ahead and share it with your friends. I look forward to helping you reach your goal of passing the real estate exam.